Okay, well, welcome everyone. Again, this is our next in a series of webinars we've been doing on Tuesday mornings at 10 o'clock. The last several have been on the topic of commercial insurance. If you recall, we previously had done one on the surprise bill legislation. Then we had done some on the state regulated plans, the fully funded plans as a general proposition. This one is about ERISA and the self-funded federally regulated plans. Before we get to the substance of it, I just want to say, hope everyone's doing well, and thank you all immensely for attending. If you are going to ask a question, please do it in your Q&A section rather than your chat section. We would appreciate that. Let me just briefly introduce the subject, and then I will introduce James, who is our managing attorney for our commercial insurance group. He spearheads that group, which not only does the surprise bill arbitrations and the state regulated arbitrations in front of Maximus, but he also does our ERISA work, which is going to be the subject of today's webinar. As all of you know, there's certain definite challenges with commercial insurance recoveries. First and foremost is knowing whether the plan that governs reimbursement is even regulated by the state or federal governments or both. So we've had a bad history with a failure to obtain the plans, and that's not necessarily the fault of the medical community. The carriers don't exactly participate, the patients don't exactly participate or cooperate. So it's been a frustrating path for medical providers because getting the plan is imperative to know what form you're even going to be operating under or within, and it's difficult to get the plans. Well, you've probably heard us talk until we're blue in the face about the importance of obtaining the plans. Now, so let's assume we have the plans, and this plan is it's an employer, typically a very large employer, where they can afford to fund the plan. And those types of plans that are fully funded by employers are regulated by the federal government under ERISA as a general proposition. And that comes with a whole set of requirements that are different from what is expected at the state level. So having said that, we are now in ERISA world on this webinar, and I will turn things over to James because the subject of today is navigating the pitfalls of ERISA, and there are many, and there are tricks, and it's very important to know exactly how to navigate that set of federal laws. So James,
yep.
Take it away.
Hey Tom, and James, this is Sean.
Hey, good morning.
First, thank you, Tom. That intro, James is going to be ready to take it away in just one moment. James, how are you today?
I'm doing great. How are you?
Okay. So what is most present for you as you are about to deliver this ERISA-based content to these fine folks?
I would say a sense of urgency. I know what a difficult time this is right now for everybody, and to the extent that we can help, and I know we can, I think this is a big area where there's a lot of money to be recovered, especially, going back into some practices backlogs. So to the extent we can help, I'm real excited about it, and I feel urgent and a sense of responsibility, not only to the folks at Callagy Law, but to our clients as well, to give as much content and help them recover as much money as I can.
That is awesome. And so we're going to let James drop in 1 second. And what is present for me is, first of all, gratitude for Tom and James putting this together and doing this. Fantastic work. And thank you for being here on this teaching platform, webinar, interactive, dynamic, and keep that chat alive with questions, engagement, what you're feeling that Tom and James are doing great. Let's give them, please, some awesome acknowledgement and feedback, and any other things you'd like to hear about and learn about as well. And again, for those who don't know, this is Sean Callagy, principal and founder of Callagy Law. What is also present for me, final, is the reality that this is a very special time. And what I'm about to say really applies predominantly to folks that are out of network, looking to generate new relationships and accelerate your growth of your practice, as opposed to folks that are fully in network, which I think most people on this line probably, or at least partially out of network, if not fully. So what is present for me is opportunity during this really challenging time to rethink how you relate to the world and how you grow and accelerate. And all I will say about that is we're having a call tomorrow at 12 noon. And Krista, please make sure that the link goes in the chat. And it is not a conversation that you will have heard before. It is about what I am very confident is the most important, innovative disruption. And I've been at the forefront of its co-creation and working on this for a long time, years, but particularly for the last 3 months, hyper-focused in creating this disruption for how you can have a much easier time building relationships with people to refer to you, and also ways to deepen connection and generate more patient referrals, all in integrity, all by adding value, all by being heart, love, and give centered, and very specific tangibles though about what that looks like and what to create. And it goes beyond, hey, have a website. It goes beyond, hey, search engine optimization. It goes way beyond, hey, shoot videos, although that's a relevant dynamic, but not exclusively relevant, to what do you do to create these platforms for people that differentiate and show who you truly are and what you can truly bring to the table. And very few people are functioning this way. Most people at best are functioning with, hey, you know, I'm nice and I'm good and come see me. It's about adding value and demonstrating differentiation, and how you do that during this Corona time and recondition behavior and beyond. So I'll say, it would be, if you want to grow your practice, it would be objectively an error to not be on this tomorrow at 12 o'clock. It would also be objectively an error to delegate it to whomever does your marketing, objectively, because one piece is the delegation of marketing for principal, which I have made the mistake of many, many times and spent hundreds of thousands, if not millions of dollars, purely delegating without understanding. And so this is the gain of understanding. You don't have to be the marketer, but you do have to understand enough how you manage and lead your marketer. And that's a key pivotal distinction. So 12 o'clock to 1 o'clock tomorrow, be there unless you have patience. There is nothing that you could be doing that's more important other than letting James and Tom begin to look into your backlog. So your actionables from today are, learn this, let us look in your backlog and find you money, and be on that call from 12 o'clock to 1 o'clock tomorrow with your marketer and your team. Thanks, Tom. Thanks, James. And have an amazing day, everybody.
Awesome. Thank you, Sean.
Okay.
Alrighty, guys. So yeah, I definitely want to echo what Sean said. I'm going to be on that call tomorrow. I'm looking forward to it. So I guess without further ado, we will get started. So Krista, you could actually jump ahead 2 different slides, please. All right, so as Tom said, today we're going to be talking about the ERISA world. Everything is self-funded that we're going to be talking about. So just looking back a little bit to sort of put all this in context as to where we are, where we've been, and where we're going. The last 2 weeks we've been talking about New Jersey state-regulated plans that have all been fully insured. 2 weeks ago, we talked about New Jersey's surprise billing, arbitration, the ins and outs of that, Maximus, how to deal with them, what to look for. That's a great webinar. I know it's posted on YouTube. We have the slides. We'd be happy to share them. Last week, we talked about 3 different New Jersey fully insured programs, the ICAP, the PICPA, and the state health benefit plans. Again, fully insured, state regulated. So today, we're going to be talking about the self-funded ERISA plans. So just a little bit of background. What does that even mean? For those of you that are joining us for the first time, I wanted to make sure that everything was kind of clear from the beginning. Krista, please jump ahead 1 slide. So what is a self-funded plan and how does it differ from a fully insured plan? A self-funded plan usually goes with a large employer. I give the example of Coca-Cola. It's cheaper for a large employer like Coke or UPS or Walmart or Target to have all of their employees, instead of contributing to pay Horizon, they contribute into this giant health fund, sort of a slush fund. And whenever one of the employees needs a payment for health services that they've received, the money comes out of the fund instead. So there's this giant fund and all the employees individually contribute to it. So essentially the company is funding it themselves, thus the self-funded moniker. The problem, though, is that Coke and UPS and Target, they're great at what they do, but they don't know how to run and administer payments from these health plans. They don't know about UCR, NCCI edits, anything like that. So they go out and they hire somebody to do it. Well, who knows how to run and administer something like that? The big insurance companies. So that's why you'll see Horizon, Aetna, Cigna, and typically United all as claims administrators in these self-funded plans, because they're essentially the ones that know how to do it, which is why it gets confusing when you're talking about the fully insured plans, because they're often the ones that are insuring those plans. Krista, next slide, please. So the difference here in a fully insured plan is that, typically small businesses that don't have a ton of employees can't afford to create this giant sort of trust slush fund where they can pay their employees. So what they're doing is they're buying an insurance policy. Heaven forbid something happens to a lot of their employees and they wouldn't have enough money in the fund. They're asking Horizon or Aetna or Cigna or United to fund it. So you're buying an insurance policy where the money is actually going to come from Horizon versus a self-funded plan where the money is coming out of the trust, but Horizon's merely administering it. So in a fully insured plan, Horizon is actually the one who's paying it. So you're just paying them in order to monitor it and run their insurance program. So today, again, we're talking about these self-funded ones. Next slide, please, Krista. All right, so as Tom was saying before, one of the big tricks here is figuring out how the heck do I know which one is which? What am I dealing with? Because as we talked a lot about last week, the plan and the funding kind of sets your feet on the path down which you're going to proceed to try to get additional money. And there's a bunch of different options depending on what path you're on. So how in the world do you find out in the first place whether you're dealing with a self-funded or a fully insured plan? Sometimes it's easy, sometimes it's on the card. Someday I hope and expect that there will be some kind of federal law, state regulations that say every single insurance card has to state it plainly right on there and even list the administrator. Unfortunately, that is not the case today, although you will see it sometimes. I did see one this week that said right on there, self-funded plan, and it was a Horizon card, so you knew right away Horizon was the administrator of this self-funded plan, made it really easy to know right where we were with the case. Other times you can just call the carrier. Often that is what my office does. Unfortunately, our awesome staff have to sit on hold sometimes for an hour or two to get through to a human and say, have a discussion with them and figure out, is this self-funded or fully insured? You can get it that way. Unfortunately, it's a bit labor intensive. You can do a written appeal, you can request the plan, but again, those things could take weeks or even months if you ever get a response. Or ultimately, you can try to file it in one of these fully insured avenues, and then if it's going to get rejected, they might say, hey, look, it's not eligible for the surprise billing arbitration because it's actually a self-funded plan. That's kind of the last-ditch effort where you just say, you know what, I'm going to file this, and if I get a rejection, at least that rejection will tell me what kind of plan I'm dealing with. Next slide, please.
We have a question.
Sure.
If an EOB states that the insurance company is the agent for the employer, does that imply a self-funded plan?
I would say the term agent is not descriptive enough. If they say administrator, you're very likely looking at a self-funded plan. I'd have to take a look at the EOB, but they're very tricky, unfortunately, whether it's intentionally deceitful or sort of just ignorant. A lot of times people are given misinformation either on the phone or on the EOBs. So I don't know whether the term agent would necessarily mean you're guaranteed to be dealing with a self-funded plan? Probably, but I would say you're looking for the key buzzword is administrator. That's the one where you know for sure that it's a self-funded plan.
I would echo that, James. I would agree, which is odd to have two lawyers agreeing on something. But I would agree that I would say it probably means it's a self-funded plan, but you can't really take that to the bank. So if coming across that, I would suggest that you proceed as if it was, at least initially, but keep in mind that it's not, it may very well not be the case, but it's probably an okay assumption to operate under, at least initially.
Yeah, I agree with that. I guess it's okay for two lawyers to agree if they work at the same law firm, but if they work for different firms, the idea is you want to disagree as much as possible. Jumping back in real quick, what forms are available? So you're talking about a self-funded plan. How do we get into disputing this with the carriers? Are there arbitration forums? Unfortunately, currently there are not any arbitration forums. The word on the street is that the federal government, the federal legislature, there's a bunch of different competing proposals for a federal surprise bill law similar to what New Jersey and New York both have that will likely create a federal arbitration system, but that has not been passed yet. I know that it was very hot to be passed at the end of 2019, and then obviously there was the impeachment, and then it had a lot of momentum in early 2020, and then obviously right now we're in the Corona situation. So I think it is very much on the back burner, not a priority right now as Congress deals with everything else. But Tom, I know you have your finger on the pulse for all the different proposals there. Can you share a little bit about what your thoughts are on the federal bill?
Sure. The latest set of options, okay, really dealt with 4 possibilities. So, and for medical provider purposes, the surprise bill legislation at the federal level, I believe, is a very welcome event. And the reason I say that is it removes the necessity to obtain the plan and gets rid of all the hurdles associated with obtaining the plan, because you don't need the plan because you'll go right to the arbitration process. But the trick, the proof in the pudding of all of that for purposes of the medical provider community is what the standard of reimbursement will be. So the difference in among the various options at the federal level always had to do with how you measure reimbursement. So on the one hand, if the standard for reimbursement is some level of reasonableness, if they talk about medical providers being reimbursed at a reasonable level, that's what we want. That's on the one extreme where we want to be, because reasonableness puts you in UCR world, which is where we are at the state level, where when it's advantageous to us, we are in UCR world. Reasonableness puts us in UCR world. That is also where we are in the state surprise bill legislation. And as long as you know how to navigate reasonableness, the medical provider will do pretty well. On the other extreme was the California model, which is based on Medicare. So if there is a standard of reimbursement that is a percentage of Medicare, unless it's a very, very high percentage, in the thousands, no doubt, as far as the medical community is concerned, but 150% of Medicare, 200% of Medicare, even 300% of Medicare is not where we want to be. And the California model is based on a percentage of Medicare. Now, there are 2 options that have been proposed at the end of 2019 that are in between those 2 views. And they basically, one of them used as a standard the average or the median in-network rate of some kind. I don't think we want to be there either. And both of the ones that were the compromise did rely, I believe, on some sort of median in-network rate, and simply had arbitration varied in there, and when arbitration would kick in. I think one of them had a $750 threshold for arbitration. The other one had a $1,250 threshold, I believe. But both of those were founded on a median in-network rate. So the surprise bill legislation at the federal level would be a welcome development as long as the reimbursement threshold or the reimbursement measure was reasonableness and not some percentage of Medicare and not some median in-network rate. So I don't know where we're going to end up with that. The hope is that we do get the legislation and that it has a standard of reimbursement that to some extent puts us in UCR world, which the reasonableness standard would do.
Yeah, you know, when I hear some of the proposals about the median in-network rate being used, to me, it demonstrates such a lack of understanding of the whole world of in-network versus out-of-network. You know, when you're a provider, you know, it's a contract. Going in-network is a contract. So both parties are giving something up and both parties are getting something. When you're an in-network provider, what you're getting is essentially referrals, access to patients. You're on those, you're probably going to see more patients. What you're giving up is reimbursement. Maybe you're also getting prompt payment or knowledge of exactly what the fee schedule would be, so you're getting some surety and some certainty. But what you're giving up is leverage and greater reimbursement, theoretically. So to take an out-of-network provider who should be getting greater reimbursement and subjecting them not even to the 100th percentile or the 95th percentile of the in-network rate, but the median is just so insane that it makes no sense to me. So whoever would propose that really is in the pocket of insurance companies or just has been lobbied or something. But I don't know, it makes no sense to me.
Hey, I have a couple things. We have a hand up and we also have a question in the chat.
Okay, yeah, I do see the question in the chat. So let me address that first. So Brooke, this is a really good question. Brooke is asking about, for those of you that are on the phone, there are guidelines in Dobie Bulletin 1418. Are those mandatory for self-funded plans or are they a recommendation? It states that all self-funded plans that opt into arbitration must have the information advertised on insurance cards. So I'll address that first. Dobie Bulletin 1418 is not mandatory, it's not a requirement. So the New Jersey Surprise Bill law got passed in 2018, and it definitely regulates all of the state regulated fully insured plans and the state health benefits program. The trick is there's some ERISA preemption issues where if a self-funded plan opts in, does this law cover them? But if they're waiving preemption and they're accepting the coverage of the law, do they have to behave in a certain way? And also, you know, Dobie bulletins are guidance. They're not binding. They're not part of the law. That wasn't in the law. So I would say it's likely that if the plan opts in, they're going to opt to follow this. But I don't think anything there is binding to the extent where you could sue. There's probably not even a private cause of action where you would be able to say, hey, they didn't put this on, they opted in, I'm going to sue them because I missed my window for arbitration, that kind of thing. So it's definitely not a guarantee that it's going to be on there. Okay, let's see. Then there's another question about, are we seeing a lot of usual and customary defined as a percentage of Medicare? We do see that. We're going to get there a little, but I guess just sort of, you know, a head fake towards what's coming. Yes, we do see a lot of plans that appear initially to present as UCR plans, but ultimately, if you dig into the plan, it defines it as a percentage of Medicare.
James, let me add to that
Sure.
response. This is why it's so important to actually obtain the plan, because you will get, when you're getting your authorizations and you'll be on the phone with the carrier's rep, they may very well tell you it's a UCR plan, but if the plan defines UCR as a percentage of Medicare, you're going to get that payment and you're going to say, hey, I thought this paid UCR, you told me it paid UCR. So it's a very cute little sleight of hand that the carriers are doing there. So no longer can you rely, if you ever could actually, on what the reps are telling you when you get the authorization. It is so critical to get the plan, because if the plan defines UCR as 150% of Medicare, you're probably stuck with that. But it would be good to know that prior to the surgery, instead of thinking that you're going to be getting a UCR reimbursement.
Yeah, so we are jumping a bit ahead. So I'm going to get back to the slide that's on the screen, and we will get more to reimbursement in a couple of minutes. So when you're dealing with this kind of case, what documents do you need? There's two different categories. The first is essentially the same documents that you would need when you're delivering a file, any medical revenue recovery file. The patient demographics, the bill, EOBs, there's an assignment of benefits, great. Any of the supporting clinical records, not just for the individual data service, but maybe the records leading up to it, if there was physical therapy that has failed, MRIs, things like that. So not just the op report for whatever surgery it is. Any appeals and any appeal responses. And if there's screenshots from the billing system, that's fantastic too. Often I get, pages and pages and pages of screenshots of called on such and such a date, reference number, this, spoke to this person, they stated this. So it's really helpful for me, sometimes a year or two later, coming in to say, hey, what's the history of this case? What's been going on here? So to the extent you guys can provide that when you're giving us the file, it's fantastic and it's super helpful. Those are the delivery documents. The other category is the ERISA accompanying documents. What kind of stuff are we looking for? Krista, next slide, please. Okay, so the ERISA documents, there's sort of 5 documents we're going to discuss today. We're going to do them one at a time. The first one is the employer insurance information sheet. The sort of broad brush 30,000-foot view. This is where you're getting the employer data, and this is where Tom was talking about how the critical nature of getting the SPD. This is where you're most likely going to be able to obtain it from the employer. The carrier authorized rep form. And for those of you that can see the slides, we put an asterisk on all the ones that should go in your intake packet. So the employer information insurance sheet should go in there. The specific carrier authorized rep form should go in there. The HIPAA authorization. And then the last two we've already touched on. The first one, which is the summary plan description. That is the plan. That contains the fee schedule. That contains the schedule of benefits, the definitions of what does UCR mean, things like that. And the last thing is power of attorney. I'm sure a lot of you that are on this have probably heard other webinars. Callagy has done this in the past. We've often talked about power of attorney. So today we're going to get a little bit more into what is it, when do you need it, why do you need it, things like that. So we will be getting there in a couple of minutes. I see there's some stuff going on in the chat. Okay, Krista just posted the link for tomorrow. All right, and Krista, next slide, please. All right, so first, the employer insurance information sheet. And here, it's important that you're crystal clear. This is the insured person's employer, which is not necessarily the patient's employer. So the example is, my family has insurance through Callagy Law. If my wife goes to get a medical procedure and she's filling out an employer information sheet, it's important that she would be putting down my information. So my employer, Callagy Law, rather than her employer, because that's the information through which everything is getting processed. You would need the SPD from my employer, not her employer. And again, the employer is the one, or their HR department is the one most likely that's going to produce the SPD when we're ultimately requesting it down the line when we need it. Next slide, please.
James, there is a question.
Sure, it's hard for me to see the questions.
Yeah, will the carrier give the provider the plan benefits, or does the patient have to obtain the benefit, the plan documents? So I guess we're kind of getting to that.
Yep,
but maybe
we're about to answer that question. Krista, if you could jump ahead. Right, so the answer to that question deals with the carrier authorized rep form. So Krista, next slide, please, again. So once you have that carrier authorized rep form, you then have the standing and the authority to request the SPD from the carrier. So that's really the answer to the question. Just as a medical provider, if you simply have an assignment of benefits in your intake packet, which might be good enough for New Jersey PIP, then it's probably not going to get you the SPD. Occasionally it may, if you include that and send it to the employer, just a random, assignment of benefits that says, I'll cooperate and an information release, maybe that'll work. But if you have the specific carrier authorized rep form, it's required to work. This is what the document the carrier says needed to confer standing, to confer authority to a medical provider to proceed on their behalf. It's important to note that every carrier has its own. So Horizon, Cigna, United, Aetna, there's 4 different forms. And this is why one of the services that Callagy provides is when providers first come on board, we give you guys everything. We'll give you all the forms, and this is where the front desk staff has to be informed and know when a patient comes in with Horizon, you got to slip that Horizon authorized rep form into their intake packet. We've all been in doctor's offices when the first thing you do is you walk in and they hand you a clipboard with 27 different pieces of paper on it. One of those pieces of paper always should be a carrier authorized rep form for the particular insurance that patient had. I wanted to note that some of these actually do expire. I think the Aetna one usually expires after 1 year, and it says it right on there. So occasionally, if a claim has gotten old, we need to go back and try to get them again.
James, can I add something here?
Sure.
Okay, so think of it this way, folks. There are 3 avenues to obtaining the plan documents, and they're all imperfect in their own way. So the first avenue is obtaining the plan documents from the patient. Now, I'm sure all of you just rolled your eyes. I'm sure all of you just rolled your eyes and said, yeah, right. The patients aren't going to bring in their plan documents. Now, historically, that was probably true. We have to start the process where patients are better at doing that. So one of the things I heard at a conference, I heard somebody mention, and I thought it was a brilliant idea, is practices have to start having a position they might call a patient insurance advisor or patient insurance liaison, where during it's kind of a concierge service, which some of you might have, but it's kind of, you're instead of saying to a patient, hey, bring in your health insurance plan, which may not land well, you say, hey, I'm going to help you understand your insurance and how your insurance is going to work and what your obligations are going to be and this, that, and the other thing. We're happy to do that. It's a service we provide to our patients. In order for me to do that, I need your next visit to bring in your health insurance plan, and we'll kind of review it and go through it together so you understand your financial obligations, blah, 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 blah. So it's if you change the way you treat the relationship with the patient when you ask for the plan, it just may land better, and you might find yourself a patient who is very amicably bringing in their plan on their next office visit or dropping it off when they get a chance. That's number one. The second avenue is from the carrier. That's where the carrier authorized rep forms come in, which James just mentioned. Having the carrier authorized rep form for that carrier puts you in a better position to reach out to the carrier to say, hey, send me the SPD, send me the plan documents. The third option, and this I'm told is the best option of the 3 in terms of results, is the employer. And that makes sense because the employer's patient, the employee of the firm is your patient. And typically an employer is going to want to accommodate their patient's needs, their employees' needs. So I think you might find them, the HR department of the particular employer, more agreeable to sending the plan over than perhaps even the patient or the carrier. And that's the reason for the employer information sheet. It's supposed to get you to the HR person of the employer, and that way you have the documents you need to get the plan from either the patient, the employer, or the carrier. And that's what those intake documents are all about, is to enable you to pursue one of those three avenues to success. Go ahead, James.
Just sort of a final comment on that. It's also in the patient's best interest that they produce the plan, because, if you think about it, you play it out towards the end of the whole process, the carrier pays what they're going to pay. And then if the patient is electively treating with an out-of-network provider, they're stuck with a balanced bill. So if the plan underpays its responsibility, that means the patient has a larger balanced bill. So it's actually in the patient's best interests. If it's a UCR plan, they want essentially the carrier to pay as much as possible to leave them with the smallest possible balanced bill. If it's a percentage of Medicare plan, they want them to pay the appropriate percentage of Medicare so that the patient is stuck with a smaller balanced bill. So it really is in the patient's best interest as well. So when you talk about the concierge service, I do see it as the medical provider and the patient working together to get the plan in order to be able to hold the carrier accountable.
James, go ahead.
Yep, I see. Okay. So again, Brooke, this is where, the question is whether you're able to reach out to the patient's employer. And this is again where the authorized rep form comes in. If the patient has given you their blessing, they have given you their standing, they have assigned those benefits to you, now you have the authority to reach out to the plan. Because if they say to you, wait a minute, I can't produce this, do you have the patient's authorization? And you have it, then you get it. I mean, all the time, every day my firm, has a claim delivered, we reach out to the plan to request the SPD. Very frequently, we get pushback and say, hey, wait a minute, we need the authorizations. We then provide them, and the plan is produced. So if you have the patient's blessing, you're not doing anything wrong.
Now, let me add to that, Ted. Brooke, no, we're not suggesting that you somehow violate HIPAA or reveal any kind of patient, protected patient health information. But what we're saying is, if you get the employer information sheet signed, part of that is permission to reach out to the employer to obtain the plan documents. You have the assignment of benefits signed. You have the carrier authorized rep form signed. You have the HIPAA document signed where the patient has given you, permission to release records, et cetera, and you're not doing any of that really. All you're doing is contacting the employer to say, hey, we have permission from your employee, John Smith, to, to receive the health insurance documents or the plan documents for the plan that they signed up for. Can you please send that over to us? So you're not really releasing anything. You're just reaching out to the employer. And that's what we're suggesting. And you have plenty of documentation signed to enable you to do that.
There's another great follow-up question to that. Assuming you have the authorized rep form, ERISA states that if you get an appropriate plan request, it has to be provided within 30 days or there's a violation. So in some cases, if we don't obtain the plan documents to obtain benefits, would it work in our favor to appeal for higher reimbursement? So it's a great question. There is a provision under ERISA where if you have appropriate standing, meaning you have the authorized rep form, and you ask the appropriate person, which is the plan, there is a $110 a day penalty if they don't provide it after 30 days. So the answer is yes, that there is a penalty if they're not providing it, and that penalty really does add up, because if they're not going to provide it right away, it likely could take a couple of months. So there is one thought where you can sue after a couple of months if you've got all your ducks in a row and they're absolutely refusing to provide the plan. You can sue seeking to remedy the payment of that $110 a day. The part about your question where you're asking, can you appeal for higher reimbursement? Simply because the plan has not been provided to you doesn't totally eradicate the provisions of the plan. So if the plan pays 110% of Medicare and that's what they paid you, you're not actually entitled to any additional money under the plan. It's not eradicating the plan's fee schedule. You might be entitled to the $110 $110 a day penalty. The problem is, now you're suing an entity, right? Like I had a case once where an animal hospital had a self-funded plan. So I'm going to walk into federal court and I'm going to be suing an animal hospital seeking $110 a day when it ultimately turns out they paid it correctly. It's a bad look. So, we try to do everything we possibly can to convince and cajole and get the patient on board, go back and forth to get the plan, because ultimately if it's paid correctly, the $110 a day penalty is discretionary to the judge. So it's not a guarantee. And it doesn't entitle you to additional reimbursement under the plan beyond what the provisions say. So hopefully that answers that question. Krista, let's jump ahead to the next slide, please. Okay, and one more. So again, we discussed the HIPAA form. Essentially, this is allowing you to share medical information. This is another one that should just be included every single time in your intake packet.
And for the most part, many of you already have pretty good HIPAA forms. So if you have, you can get some of these online that are very detailed and very lengthy. But for the most part, if you have a pretty good, complete HIPAA release form, that'll generally do the trick for you.
Yep. All right, jump ahead, please. There we go. All right, so now we're talking about the SPD. We've already covered a bunch of this stuff, but it is important to go over it slowly. Each plan is different, right? Every single employer has their own deal with the plans. If it's self-funded, each administrator administrates it differently. They each provide benefits differently. Some are better, some are worse. So the way that I first explain it is, most of the providers here are familiar with PIP and no fault in New Jersey. There's a state calculated, state put together fee schedule. So if you perform X procedure, you can go right on the Adobe website and they're going to tell you you're going to get X number of dollars. In workers' compensation in New Jersey, there is no fee schedule. Everything is reasonable and customary. Can go up, could go down. You're going to ultimately fight about it, as we were talking before, in the world of reasonableness. Commercial insurance, it's closer to PIP in that there's almost a fee schedule, except the fee schedule is not state produced. It's not on Adobe's website. It's buried inside the SPD, and it's not one size fits all. Every SPD has its own fee schedule. So that's why it's so important to get a copy of that SPD to know what you're dealing with, because the same operation is going to get paid 8 different ways to 8 different patients by 8 different plans. So you really don't know what you're dealing with until you get the SPD. Similar to PIP, if it's a Medicare-based fee schedule, if you bill $100,000, maybe you're only going to get paid 8. But if that is what the plan calls for, if that $8,000 is 200% of Medicare or 350% of Medicare, if they pay it appropriately, we're not going to be able to recover more money because they've paid it appropriately according to the plan. Now, the more high dollar recoveries usually come from UCR-based plans. So if there's a plan that calls for reasonable and customary, or if it's unclear, these are very few and far between if it's unclear, and these ultimately usually will result in litigation, but let's assume it's just a clear UCR plan. This is where there's going to be more gray area. They're going to say, hey, we paid you what we paid you. We're going to say, how do you justify that? Here's a bunch of proofs. Here's sometimes you paid us for these procedures last year. Here's what other carriers are paying. Here's what Fair Health or Wasserman or Ingenix pays. You're going to be able to build a case and show that their payment was not reasonable, was too low. And hopefully in the pre-litigation stage, they'd be willing to settle. Otherwise, you're going to end up in the litigation stage, which we'll get to in one more second. Next slide, please, Krista. Okay, the sort of one exception here is emergency services. Almost every single plan that I've seen has a carve out and exception for ER services, and almost always, reimburses them higher. So if general elective services are reimbursed at a percentage of Medicare, 200%, 350%, whatever, almost always there's a carve out for ER, and it almost is always at UCR. So if you're a provider that works out of the ER, it's even more critical to get the SPD, because a lot of times what will happen is they will not pay it as if it's an emergency service, particularly if it's a like follow-up where the patient went in through the ER, they were admitted as an inpatient, and then subsequently a day or two later, some kind of surgery was conducted. I've seen a lot of cases where that surgery just gets processed as an elective out-of-network surgery and paid at a percentage of Medicare, but in reality, it's an emergency surgery. And they have not applied the carve-out, the kick-up, where it should be UCR or it should be double or triple the reimbursement. They're still paying it as an elective out-of-network procedure. So that's why it's super important to get the SPD, and that's where the lawyer challenging the determinations really comes in handy.
James, let me add something to that. So we talked about the challenges that exist to get the plan documents, even in an elective surgery context. So even when you have an elective surgery, there's been a challenge to get the plan documents. Now you have the ER context. So it's virtually impossible to get the plan documents, given that it was an ER encounter, because patients aren't showing up, in the ambulance. When they come in on the gurney, they don't exactly have their plan documents with them to hand to any out-of-network surgeon that may have to treat them. So this is a particularly tricky area, and this is why the surprise bill legislation at the federal level is so beneficial to providers, because it gets rid of all of those challenges. But in the meantime, now how the heck do you get plan documents if it was an ER encounter? Well, that's tough. I recognize that that's a challenge. My suggestion always is do what you can to get the patient to your office for a follow-up visit. Now, typically that's included in some sort of global, so it's not going to cost the patient anything, and you really want the patient to get to your office, not necessarily for a follow-up office visit. You really want to get the patient there so that you can have your intake packet that contains an employer information sheet and contains a carrier authorized rep form and all of your HIPAA forms, so that you can get that patient to sign all of those documents you need in order to be able to get the plan from somebody at some point. Unfortunately, it'll be after the fact, but after the fact, getting it after the fact is better than not getting it at all. Go ahead, James.
Yeah, that's an excellent point. And particularly nefarious here because, emergency services are typically the higher level stuff. And then if it's not getting paid correctly, it's that much harder for an ER doctor to get the documents to prove that they're getting paid incorrectly. Next slide, please, Krista. All right, so now we're going to talk about the powers of attorney, the much ballyhooed, that much discussed. So first, I do want to note that in New Jersey, these must be notarized. I know that can be tricky, but we really do see them all the time. Some offices get these 100% of the time. They have a notary on staff. It's part of the intake packet. They address it right away. Tom knows who I'm talking about. It's one of our southern New Jersey providers. Others, sometimes we do get lucky and we'll mail the patient the form later on. Even in Corona, I've actually gotten a couple in the last couple of weeks where the patients have gotten them notarized. So it does happen. But again, the more proactive you are, the more you know about it and are planning for it, the more likely it is that you're going to be able to get one. Next slide, please. And this brings us to, when do you really need one? What type of case? So as important as it is when you need it, it's also not needed that often. There's essentially 5 criteria necessary for needing a POA. First, you got to have the SPD. And I know, again, just like last week, we're throwing a lot of alphabet soup here at you guys, but hopefully we've explained everything and you're sticking with me. But if you have any questions, please let me know. So the first step is you need to have the SPD. You need to know you're dealing with a UCR plan, whether it's an emergency service or an elective service, that's a great plan. It's going to be paying you at UCR. The third step is negotiations or appeals have failed. So you know you're in UCR world, you think you're underpaid, you've tried the pre-litigation strategy, you've negotiated, you've appealed, you're still out. The fourth step is, in that SPD, it says there's an anti-assignment clause. So something like, assignments of benefits cannot be made. This issue, whether an anti-assignment clause is valid, actually did go up to the Third Circuit Court of Appeals. And the court said these types of anti-assignment clauses are valid. However, a power of attorney, they did very strongly hint, is good enough to confer standing to a provider to litigate these types of issues. So I don't believe that's ever been like totally rock solid, nailed down, but this is one of those things in the law where they hinted so strongly that it would be a fairly stunning reversal of their position if they were to not uphold a signed, appropriately notarized POA at this point. And the last step is, yes, Tom?
Let me just add this. This is an area too where having that person in your office that is a patient insurance advisor might come in handy. It's a lot of providers are reluctant to put the power of attorney in the intake packet because it needs to be notarized. So if your front desk person is not a notary, or you're not sitting down with the patient explaining to them why a power of attorney is necessary, it may be hard to get them to sign it in the intake packet. So another function of this patient insurance advisor could be to sit down with them with the power of attorney and explain to them, hey, I'm a notary, I need you to sign this in front of me, I need to witness it. Here's why we need this. Your healthcare plan may very well not allow us to recover appropriately from your insurance carrier. This power of attorney is limited to this treatment, and it's limited to us being able to pursue your carrier in court if they underpay us. So that's the nature and the reason for this power of attorney. Otherwise, it might be a little scary for a patient to try to sign that because they're not really having a good understanding on why it's necessary. So the insurance advisor person, the patient liaison for insurance, could very well explain it to them. And if they're a notary, you might be able to get them to sign that fairly early on before the surgery takes place. Just another bit of advice, practical advice. Yep.
Point well made, Tom. And the last element here is that it has to be a large enough case. The UCR dispute has to be big enough to justify going into federal litigation. So, honestly, I don't see a ton of cases where all 5 criteria are met. Sometimes we're not able to get the SPD. Often if we do, it's not a UCR plan. Often if it's a UCR plan, they're willing to negotiate, they're willing to settle. If they're not willing to settle, sometimes the plan doesn't have an anti-assignment clause. So you could sue with just the authorized rep form or an assignment of benefits. Or lastly, if they paid the 75th percentile of fair health and you're looking for the 80th, and it's a $2,000 or $3,000 difference, maybe it's just not worth going into federal litigation. So again, you need all 5 of those really to justify needing a power of attorney. So given the fact that it's only necessary in a small percentage of cases, why do we spend so much time talking about it? Well, the reason is when you need it, you really want it, because think about having all those elements present. It's a big case, it's UCR, there's an anti-assignment clause, and you think you've got a good case here. If you don't have it, it's a real shame to let that case go to waste. And the other reason is if you really don't know for a long time often how big the case is going to be and whether these elements are present. We're talking about months, sometimes years down the line after the service. So at that point, to try to go back and find the patient, they haven't heard from you for a couple of years, maybe they've moved, you can't find them, or they're not willing to sign it, virtually or whatever, years later, it's just so much harder to get the POA at that point. So that's why we do recommend getting it on the front end, and we talk so much about it. And it's not just a form that says power of attorney splashed across the top. New Jersey really does have specific requirements. And again, that requirement that it be notarized is particularly onerous and requires planning in advance. So that's why we do talk about it so much, because it's just so hard to get on the back end, 2 years later. So last slide, please, Krista. So that is all of the material that we wanted to discuss today. We're coming towards the 11 o'clock hour. So if anybody has any other questions, if there's anything that's unclear, please feel free to jump in at this point. If you've got anything for the chat. Tom, any other sort of words of wisdom you want to share?
Yeah, I would like to kind of sum things up with the following description of the following two scenarios. Okay, so historically, providers would send us major med files when we used to call it way back when we referred to this as major med. Now we refer to it as commercial insurance. But so we would get a file, and the file would contain some patient demographic information, which would probably include the AOB and a HIPAA release and some other consents, that sort of thing. They would send us the bill, which was the HICFA or the UB. They would send us the EOB, and they would send us the clinical records, okay? Now, you have that set of documents, and think about, after hearing this presentation, think about what you're supposed to do with that set of documents. You have no permission from the patient to reach out to the carrier or to appeal. You have no employer information, except maybe they wrote down their own employer on the intake question, who's your employer? It may not even be the employer that has the plan. You have no way to get the plan. The patient's not going to give you a plan at that point. You don't even have the correct employer information. You might reach out to the carrier based on the EOB, but James, as you said, maybe it's a fully funded plan, maybe it's a self-funded plan. We don't even know. We'd have no carrier auth form for the carrier to even respond. So the carrier ignores you. And so you're in this situation where you're totally in the dark as to what the appropriate next steps are. Now that's history. That's the old scenario. The new scenario is this. You send us a file. The intake packet has all the employer information. It has the carrier authorized rep form. It has the AOB and all the other things that are typically in the intake. You send us the bill, you send us the EOB, and you send us the clinical records. Well, now that's a whole different ballgame, because now we can reach out to the employer and obtain a copy of the patient's plan. We have the carrier authorized rep form to reach out to the carrier to get the plan. We get the plan, or even better, you got the plan and you're looking at the plan and you're saying, hey, this sounds to me like it's a UCR plan. It's not that, it's pretty complicated and convoluted, but it sure as hell looks like it's a UCR plan. And I only got paid $6,000 for this $100,000 spine surgery. Something's wrong here. Hey, Callagy, take a look. Right? I mean, what a world of difference. In the previous world, you're completely operating in the dark, having no idea what the right reimbursement's supposed to be or how to even get to it. In the new world, guess what? It's a simple answer. You get the SPD maybe a week or two after you try to request it. You take a look at the SPD, at least you know where you stand. It's either you're entitled to more reimbursement or there's bad news. Hey, it's not a very good plan. I'm afraid you were reimbursed properly, even though it's bad. So we have to get to this latter scenario because the former scenario just doesn't work. It really didn't work in the past, but we can't proceed on that suboptimal basis. We need to come into a better world where we optimize the process, and that means being better at getting the plan.
Yep. Julia, I see your question. I'll get to it in 1 second. Just to sort of dovetail off of what Tom was saying, I would say if there are two things that you take away and nothing else from this entire program, it would be getting that carrier authorized rep form for the correct carrier signed and the employer information sheet. With those two things, that sort of unlocks everything else, getting the SPDs, seeing whether it was paid correctly, doing the appeals, everything like that. So the two takeaways, that carrier authorized rep form, sometimes also called a designated authorized rep form, a DAR, and the employer information sheet will really, really help your practice. Julia's question is, if you get a power of attorney at the initial visit, can you use that to obtain the SPD? The answer is yes. I would say, though, the more appropriate document is the authorized rep form. And if you're able to get the POA, probably the patient is also going to be willing to sign the authorized rep form, because that doesn't even need to be notarized. That can just be totally included in the intake packet that they fill out. It's almost like swatting a fly with a bazooka. It's kind of unnecessary and over the top. It does technically, or it should, confer that legal standing, but the appropriate document would be the carrier's authorized rep form at that point. Brooke, thank you so much as well for joining. I'm glad you enjoyed it and found it informational. We're happy to have you here, and thank you to everyone who joined us this week. I know we're going to be having another one next Tuesday at 10 o'clock. I think the topic is still TBA, but we will make sure we get everybody the flyer in advance so you can click on the link and join us again. As always, I will be sending out the slides, the copies of everything. So with that, Tom, you got anything else to add, or should we wrap this up?
Sorry, guys, I got in a call. Any other questions? We're all good? And no more questions? No more comments?
Yep, I think that's everything.
Okay, well, let me give a great big shout out to all of you attendees. Genuinely appreciate your attendance. Some of you have been here for the entire series. Thank you so much for that. James, thank you. Thanks a bunch for this, all your efforts with this series. Now we do have an ebook coming out that will be putting all of these CI webinars together in some sort of convenient format for everyone. That's going to be available. We're going to be doing that for PIP, workers' comp, commercial insurance, and then we're going to be compiling them all together in a book on medical revenue recovery ebook. So everyone keep an eye out for that. Those will be going out to all the attendees. So look forward to that. James, anything you want to add?
Nope, that's it. Everyone stay safe and healthy. I hope you're all doing well, and we'll see you next week.
Thanks a bunch, guys. Bye now.
Take care.